Yes.
Nobody mentioned.
Item number 1.
Your Lordship.
Mm.
I'm for mentioning.
Yes.
Item number 4. Your Lordship,
Yes.
since conducting council is not available today, kindly this matter may be fixed on 2nd of February.
2nd of February.
Yes, yes.
Learned Council, Sri such and such makes a mention for listing the matter on 2nd February 2026 as the conducting council is out of station.
Yes, yes.
Out of station. Stop prayers allowed. List on 2/2/2026. Yes.
There is an interim order. Kindly it
The
may be
interim
continued.
order passed early shall continue till the next date.
Your Lordship,
Other side, have you taken the consent of the other side, PP?
Your Lordship, this matter is being proceeded ex parte.
Okay.
Here, Your Lordship, I'm mentioning one more case, which is CRP 09 of 2025. This instant case is connected to this same matter. So both of
You
them may
want it
be
listed
clubbed together
together?
and listed together on a set day.
Give the number. This that is also in admission stage.
Yes,
It's
in
also-
the admission stage.
The-
Both are connected matters.
It is also mentioned by the Learned Council that Civil Revision Petition 9/2025 is a connected matter and the same may be listed along with the present case. Accordingly, list Civil Revision Petition 9 of 2025 along with this case. That will do, no? Yeah. Yes, anything?
Your Ladyship, I beg to mention item number 3. The amicus curiae Learned and Anju is out of station, so kindly I seek for an adjournment.
Okay, when do you want?
After a week.
After a week. Learned Council, MS such and such, your name?
Kiloya.
Submits that the amicus curiae, Mr. such and such is out of station and accordingly prays for listing the matter after 1 week. So prayer is allowed list after 1 week. Yes,
Highly obliged.
May I please, Your Lordship? I beg to mention item number 20, Your Lordship.
item
Number 20, Your Lordship.
20.
Dear, the service upon respondent number 4 is still awaited, Your Lordship. So, maybe
Respondent
number 4, Your
4.
Lordship.
Learned Council, such Mrs. Such and such appearing for the petitioner submits that the service report on respondent number 4 is still awaited and therefore prays that the matter may be listed after the service report is received. Stop. Accordingly, list after 4 weeks. Awaiting service report on respondent number 4. Yes.
Okay.
My Lordship,
Hmm.
item number 10. I'm on behalf of Mr. Ojingpada. He is unable to attend today due to some medical emergency. Matter may be fixed for tomorrow.
Learned Council and Miss Such submits that Mr. Ojingpada, Learned Council for the respondent.
Yes.
Respondent is has some difficulties today and accordingly prays for listing the matter tomorrow.
Must oblige.
Pray so yeah, praise the Lord list tomorrow. Yes. Anything else?
May it please, Your Lordship.
Yes.
Lord, we are before your Lordships
Item number 1.
seeking prayer for quashing of the impugned FIR.
Hmm.
Lord, before taking to your Lordships to the background before the lodging of the FIR, I would like to first draw your Lordship's attention to the FIR that is impugned in this present case, your Lordships. Lord, will kindly have a look at the FIR dated 5/9/2025, starts at page 76, Lord.
Yes.
My Lord, see page 79, my Lord. My Lord, see the top. This is dated 5/9/2025, my Lord.
Yes. 5/9/25.
The date has a relevance, my Lord. I'll come to that later on, my Lord. Your Lordship would see the name of the accused And who is the informant, Lord? Mr. Tayo Talom Rending, proprietor, Mrs. Tayo Enterprise. Lord, he is the informant herein. Accused is Talum Lombi, accused number 1.
Taluk Lombi.
Lord, he is proprietor of DTL Ventures, your lordship has got.
Yes.
Second is Mr. Rakesh Kumar Singh.
No,
He is
accused
based in
number two
Goa.
is the petitioner here.
Yes, he is the petitioner, Lord. I am obliged to your lordships. Third is Miss Dubi Ete. She is a lady from Arunachal Pradesh. Now your lordship would see, I beg to inform you that I am a registered class 1 contractor of the state of Arunachal, executed various construction work of so-and-so, so-and-so. The accused number 1 is also a contractor and proprietor of so-and-so. Lord, accused number 1 is a contractor who came to know that I have pending bills at Rural Work Department for execution of following works. So, my lord, the informant had pending bills of 17 crores 90 lakhs, my lords. And the accused number 1 came to know about it. Now your lordship sees. The accused number 1 has the criminal conspiracy in connivance with accused number 2 and 3 approached me in my office. It is the accused number 1 who, after knowing it, approached the informant. And he has criminal conspiracy with the accused number 2 and 3. That is the scene that has been projected. And he has good link in the department, Lord, because he himself is a contractor. So he's a good link in the department and having good relation with political leader of this area in the present government of Arunachal Pradesh. The accused number 1 and 3 told me that the accused number 1 has a good link in the Ministry of Rural Development. So accused number 1, being a contractor, he is showing his links, milords. What is the purpose? The purpose is that his bill should be released, milords. That is the objective. Now, and they will be sanction order for the aforesaid pending bills against the work done by me within December 24. Lordship sees that they will get the sanction within 24. The accused person asks rupees 2 crore 40 lakhs. My lord will kindly take note of the amount for their to and fro expenses to get the sanction order from the government. On dated 69, I paid rupees 1 crore 39 lakhs. My lord will also take note of this payment as well as the date, 1 crore 39 lakhs from my account located in Naharlagun Bank of Baroda, Naharlagun branch to accused number 1, Mr. Toluk Lombi, in his firm account DTL Ventures. So, my lord, the payment of 1 crore 39 lakhs has been made in the account of accused number 1, my lord. Am I clear to your lordships? Now, my lord, after payment of the aforesaid amount, the accused person came to my office on 7/11/24. But it is accused number 1 who has come with a letter bearing number so-and-so by Rajesh Bhardwaj to government of Arunachal Pradesh, allocation of fund under PMIG for a sum of rupees so-and-so against my firm so-and-so, purportedly so sanctioned of 15 lakhs. After going through the letter, I got doubt about the authenticity of the letter mentioned above. They told me that it's sent through WhatsApp from Delhi. I need to pay them again 1 crore 1,26,000. But who is the person who has shown him the letter? It is the accused number 1 and further asking 1 crore 1 lakh. Though this gentleman has doubt, Lord, still he pays. The accused number 1 himself is a registered contractor and accused number 3 is a local lady. On good faith, the aforesaid amount paid to them on dated so-and-so, 33/2025. But this payment has been made to only 2 of them. And they assured that government release the money very soon. I went to the office of the chief engineer to inquire about the allocation of fund and also the authenticity of the letter mentioned above. The chief engineer arrived to inform me that no such a letter received and it was a fake manufactured and fabricated document. But it is accused number 1 who has shown that letter. It is a designed criminal conspiracy and impersonation act of the accused person. I called the accused number 1 to return my money. What he wants now, Lord, he wants to return his money, which was fraudulently taken by them. Then the accused number 1 told me that the accused number 2 has done all the conspiracy against me, who is a habitual offender, and all the accused persons has shared the aforesaid amount. So, my lord, what does he say? It is the version of the accused number 1, my lord, who says that petitioner herein is the mastermind. And they all have shared the money. My lord had seen that all these payments initially has gone to accused number 1. Now, therefore, I request you to register case under so and so, so and so. But these were the facts. Now, your lordship has seen at two places my name has come at the initially, and that too by the version of accused number 1. Now, my lord,
And then how the accused two comes into the picture?
well, that is the question, my lord. I'll show to your lordships. There is nothing against him. What has happened is, my lord, your lordship has seen the name of the lady, Miss Dubi Eti, my lord.
To be at the-
She is also a businesswoman, my lord. She and the petitioner herein, my lord, have jointly worked for licensing of contract works with various departments, my lord. And that's how, my lord, they have contacted. Now, the petitioner herein is doing a different work, my lord. My lord, what has happened, I will show to your lordships. If your lordships kindly peruse, my lord.
It's okay, we'll-
Yes, yes, but I have to go to the facts, my lord. Otherwise, I cannot demonstrate before your lordships, my lord, that nothing could be alleged against the petitioner number 1. My lord, what has happened is, from a reading of the FIR goes to show as if the informant does not know accused number 2. But the fact of the matter is quite different. If your lordships come to page 21,
Page 21. Yes.
my lord, this is a power of attorney, my lord. Your lordship would see general power of attorney. At page 23, if your lordship sees.
Yes.
I, Tayo Talam, rending son of so and so, so and so, so and so, having his registered office, appoint and authorize Rakesh Kumar Singh, son of so and so, as my true lawyer for the purpose
Okay.
hereunder. So, my lord, he authorized me for what, my lord? If your lordship would see the schedule at page 25 for his business and for his bank account. So, my lord, on 14/9/2024, I am having a business relation with him, individual. I have also made a statement, my lord, that this gentleman has been awarded a contract of a huge amount for which he is supposed to pay a sum of rupees 11 crore to me and Dubi Ete, my lord. And in fact, so far as the accused number 1 is concerned, my lord, your lordship again would come to annexure 2, my lord. I have given the type copy.
Wait.
Sorry, my lord.
This Tayo Talom is the informant, isn't it?
Yes, yes, yes.
Hmm.
Lord, he also issued a power of attorney to me in respect of his vehicle, which your lordship seen at page 27. It is on 10th of December.
Hmm.
Your lordship has seen the payments date, my lord. This gentleman has already taken that money. There is nothing, if at all they have made doubt against me, my lord, he would not have entered into any dealings with me. Now, my lord, I also have helped the accused number 1 to get a contract at page 29, your lordship would see. This is the type copy.
Hmm.
This is how I also have business dealings with this gentleman. At serial number 2, DTL Ventures, my lord, he has get an award subcontract from NC Banerjee and Sons, my lord. So this is the also, my lord, we are annexing here. Now, what has happened is, my lord, to show my bona fide, my lord, I have also annexed the payment schedules, which I made. If your lordship would kindly come to page 36.
56. Yes.
This to show, my lord, I have got business transaction with Miss Dubi Ete. This is the ledger account. In the left hand side, if your lordship sees, 21st February 25. It's 25. I am making first payment to her of 19.5 lakhs. My lord has seen in September they had received 1 crore 39 lakhs. So she had not made money payment to me. Whereas on the right hand side, your lordship would see part payment, small amount from other works have been made to me by Dibu Ite because we are having a business relation. Similar is the case at page 37 if your lordship sees. She makes me, because we have business dealings, my lord, she had an amount of 47 lakhs payable to her by me. I am acknowledged that amount, but that is not the source that directly Mr. Talom has paid me. It has been paid to accused number 1, my lord, and from there it has been paid to Dubi Ete. Now what happened, my lord, that in July 2024, my lord, she approached me that we had entrusted a work. I have read at para 7, if your lordship for a moment read para 7 of my pleadings.
Yes.
that the petitioner state that Ms. Dubetian informed him that part of the payment made by her to him was from the proceeds received from respondent number 2, informant, and she requested petitioner to help her and suggested that they could adjust the amount receivable from respondent number 2, informant. Ms. Dubetian also requested the petitioner to give a joint acknowledgement of the amount received respondent number 2, informant, and issue him a letter of adjustment for safeguarding the respondent number 2, informant. Accordingly, the petitioner and Ms. Dubetian executed a joint acknowledgement and declaration dated so-and-so and submitted a joint letter. Now what happened, Lord? He is after her. So she comes to me, says, see, some payment I have made to you. So we owe him money, it should be returned. Since we don't have money, let us give a declaration. Now your lordship sees as page 53.
Page 53.
Annexure 8, Lord.
Yes, acknowledgement.
Yes.
Hmm.
I, Sri Rakesh Kumar Singh, petitioner, and Ms. Dubetian, so-and-so, do hereby acknowledge the receipt on amount of 2 crores 42 lakhs. On transfer from so-and-so, so-and-so, Tayo Talam Rending through Toluk Lombi. The amount was transferred so-and-so, so-and-so. We further declare that Lombi has no role in the matter and therefore we do hereby undertake the full responsibility of the aforesaid amount and same has been partially adjusted against the due of Tayo Talam Rending towards amounting to 8 crores. My lord will kindly take note of the date. This declaration is 10th of July 25. At the bottom, if your lordship would see, this is notarized.
10 July
Yes.
25.
And your lordship had seen that FIR was lodged on 5th of September. After this acknowledgement, my lord.
5th of September. Hmm.
Now at page 54, your lordship would see the letter. So it's been issued jointly by both of them, petitioner and Dubetian, my lord. Now what has happened, my lord?
What does this say? Page 54?
Page 54 is a letter, my lord,
Okay.
regarding adjustment of amount. Because the petitioner and Dubetian has given him a contract, a huge amount, on which they were getting an amount of 11 crores from him, from the informant. He has partly paid around 3 odd crores, 8 crores was balanced. So they were saying, you adjust that amount. This is, in that respect, this letter has been given, my lord. Now what has happened, my lord?
Balance amount in this one.
The informant does not rest at there, my lord. He lodges an FIR on 5/9, which I have read to your lordships, my lords. My lord, this is predated. My lord, we have only admitted the liability. I am not accepting the criminality. What we are saying is we are owing money, I'll pay you. So at best, so far as petitioner is concerned, it's a civil liability. And that too, I am taking a burden on behalf of Ms. Dubetian, not from criminality of myself itself, my lord. Now what has happened, my lord? Your lordship has seen on 5th September, he lodges an FIR.
Yes.
Then what happens, my lords? Police take into custody both informant, both accused number 1 and 3.
Entry. Yeah.
1 and 3. But I am not aware what is happening. Now, then an agreement is executed, settlement deed. They are there in custody for 2 days. They have never been arrested. Now at page 61, your lordship would see. Your lordship would see between whom it has been executed. Toluk Lombi, he is the accused number 1.
Okay,
And
And
Tayo
the
Tolam,
informant.
he is the informant.
informant.
Now, my lord, here everything has been narrated. At next page 62, your lordship would see, during the payment time of 2 crores 40 lakhs. Now, what he says, my lord, now he comes in clause 1, your lordship would see. Against that amount of 2 crores 40 lakhs, the informant also become little greedy. Now, he says that you have to pay 4 crores.
With interest.
With interest, I have taken 5%, my lord. That is beyond the statute that is prevailing in state of Arunachal Pradesh. Anyway, my lord, besides the point. And then what happens, my lords? The relative of accused number 1 has been forced. Your lordship would see Dr. Luxi Jisen to mortgage his property.
Who happens to be sister-in-law of the first party.
At clause 2, your lordship has seen.
Okay, okay.
And the time of 14th February 2026 has been fixed. And very interesting is, my lord, clause 7, your lordship would see that it is agreed by the second party that he will withdraw the FIR dated so and so in connection with Naharlagun PS case. So, my lord, his basic grievance was against accused number 1, and he has made him to come to a settlement and that to a higher amount, and then he says he will withdraw. So I have nothing to do with him. Only I have acknowledged a debt as regard the accused number 2. Then what happens, my lords? Then the accused number 1
And they were not arrested, isn't it?
yes,
One
they were
and
not
three.
arrested.
They were not
Rather, my lord, what happened now? Both of them come with Arunachal police to Guwahati in my search. Somehow I could not get arrested, my lord. And then they execute a similar kind of agreement with me. I have no option but to execute that agreement. If your lordship kind see page 68.
68.
But very interesting facts, my lord.
Wow,
Page
this is
68,
between-
16.
Between you and that Dubiete.
Yes. And Taluk Lombi, my lord, page 70. Both are there. Now they are trying to shift the burden. Why? Because I have given that acknowledgement letter. And top of it, what, my lord? They have sought a check of 4 crores from me. They also want another check of 4 crores from my guarantor. I had no option. Otherwise, I would have been arrested. I agreed with this agreement, my lord. I thought we'll have some breathing time, my lord. And there we were not aware. My lord, an impression was given as if both these accused, Dubieti and Taluk Lombi, has lodged an FIR against me. And the police has come in regarding that FIR. They even did not disclose me the FIR. It was only at the time of execution of this agreement, your lordship sees as page 71 at the bottom, the same FIR number has been given, written by hand at the time when it was executed, so that I also don't come to know. Now, my lord, when I came to know about the FIR, I obtained a certified copy on 8th. And I have also filed a title suit, my lord, in civil court in Guwahati, my lord, that I have annexed, my lords. At page 96, title suit 36. But the learned court of civil judge has granted me an ex parte ad interim injunction yesterday, my lord. Now, we have applied for certified copy that has not been made available as of now. My lord, it's an information which I am placing before your lordship, my lord, so far as encashment of the check goes. Lordship sees the accused are there who have never been arrested. The informant is seeking 4 crores out of 240, and even that entitlement is also not legal, my lord. That you want to get your bills cleared, and that to that connection. Only my name has been dragged because I have given an undertaking. But this is totally an abuse of power of law, process of law. And my lord, I have been issued. What has happened, my lord? A 35(2) notice has been issued to me. Later, when I my lord, applied for certified copy, I saw, my lord, the warrant of arrest has also been issued behind my back. A notice has been issued, but my lord, the address.
Why you have also executed this MOU again?
My lord, I had no option. Police is at my door. Like, my lord, your lordship would see, they have executed a settlement deed on 49. Why? Because they should not be arrested. Now they want to shift it entirely to me.
Okay.
So I'm
Please-
praying, my lord,
so
at this
please-
stage, my lord, let no coercive.
No coercive action is
My lord,
heard learned counsel for the petitioner. Mr. You are
R. Dubey, my lord.
R. Dubey. Stop. The learned PP PP accepts notice on behalf of respondent number 1.
The 2 will take steps.
Yes. And the petitioner is directed to take steps in respect of respondent number 2 by inland speed document within 3 working days from today.
My lord.
So, Bara, this application under section 528 of the BNSS has been filed by the petitioner, assailing the impugned FIR registered on 5/9/2025 as Naharlagun PS case number 123/2025 under section 318 clause 4 and 3 clause 5 of the BNS. Stop. The petitioner, the learned counsel for the petitioner, by taking this court to the FIR dated 5/9/2025, has sought to show that the main accused is Mr. Taluk Lombi and Mrs. Dubé Ete. Stop. It is shown from the FIR that the present petitioner has been arraigned as accused number 2. However, he has nothing to do with the instant case, as the amount alleged to be paid by the informant amounting to rupees, total was 2 crore something, isn't it?
2 crore 40 lakhs.
Amounting to rupees 2 crore 40 lakhs 42,251 was never paid to him, nor had he received the same. Stop. It is stated that a civil suit has also been instituted by him, which is title suit 36 of 2026, pending before the Civil Judge Senior Division number 1, Kamrup M at Guwahati.
But it would be 3 because while filing, given is 1, but when the matter is been assigned, it is before now civil judge number 3.
Okay. Before the Civil Judge Senior Division number 3, Kamrup M, Guwahati. Stop. Para. Issue notice returnable within 4 weeks. Stop. The in the interim, it is directed that that no coercive steps shall be taken, no coercive action
My lord.
shall be taken against the present petitioner till the next returnable date.
My lord can give a fixed date, my lord.
List on. Give a date after 4 weeks.
Lordship, record may be called from Lordship.
Yes, we will call. CD. CD or
Lordship is FIR that the already search sheet has
already
been
charge
framed.
sheeted.
Yes, Lordship. Page number 83, Lordship.
No. Charge sheet has not been filed.
Today speaks for FIRance of Ionesis.
No, this
CD or
this order was regarding issuance and NBWA.
This is 20.
not charge sheet. Doesn't.
I don't think it's.
No, it's not.
So you have to give
Yes,
the CD.
CD, Lordship.
CD.
Please. Learned PP shall also produce the updated CD on the next date. List on, give a date
Uh,
after 4 weeks.
no, Lordship, it will too long, Lordship. For first week of February, Lordship.
My lord, let it be. First week. One enough.
Isn't it CD?
No, notice on R2 also has to go. So that will take some time.
Today is
The-
19.
Today is 20.
20.
Today is 20.
The be it on second week of the February, Lordship.
So
23rd, my lord. 23rd February.
23rd February.
Deeply obliged.
Item number 2.
My lord, in respect of respondents, my lord, service is still awaited, man.
Yes,
In respect of the respondents, my lord,
Huh.
service is still awaited, man.
service awaited.
Yes, man.
It was sent for mediation. However, the matter could not be settled.
No, my lord, that is item number, might be, my lord, 9, my lord.
This is item 2,
Lord,
MSC 22 of 22. Item
yes,
2.
so,
So in item 2, it says that by order dated 26/9/25, it appears that the matter was referred for mediation. However, the matter could not be settled through mediation. So it has come back. So Wakalat Nama not yet filed on behalf of respondents. Okay. The office note dated 25/9/2025 indicates that the registry had referred this matter to the mediation center. However, the matter has not been settled in the mediation and it has been referred back to the court. Stop. Office note dated 7/1/26 also indicates that Wakalatnama has not yet been filed on behalf of the respondents. Stop. Accordingly, list the matter after 2 weeks. in order to enable the respondents to enter appearance. Okay. Heard learned counsel for the appellant, Mr. Sergeant.
On behalf of T10. On behalf of T10.
Okay, on behalf of
T10.
Taye is present.
Machado.
Item number 5.
What is this?
My lord, this is the joint application. Is being filed for quashing of FIR dated 06 January 2020 in connection with ITA Women PS case number 01 2020 under section 376 417 of IPC. So, my lord, here
Petitioner 1 is the
wife. Yes, informant. Yes, informant.
Petitioner 2 is the accused.
Accused, yes. So this is joint application. Actually, fact is that there was a misunderstanding.
Okay, so you entered into an agreement.
Yes, yes. That is page number 21, 22.
21.
My lord,
It's between husband and wife.
yes. Now, as we have one issue also, one child, the daughter.
Yes, PP will.
Lordship, yes, Lordship. As per
Because
the,
it's a purely
yes, Lordship. They have,
medical
yeah, they have registered marriage also, Lordship, in the annexure to Lordship. There I have no objection. Lordship.
learned counsel for the petitioner. Mr. Your name.
T. Dukom. T. Dukom.
To come for stop. Also heard Miss L. Hage, learned public prosecutor. Stop. Para. This is a joint petition filed under section 528 of the BNSS for quashing of the FIR dated 6/1/2020 in connection with session case number 14/2022 in ITA WPS case. ITA is what? Itanagar?
Itano Women
In-
PS
okay,
case
in
number.
Itanagar Women PS case number 1/2020 under section 376/417 of the IPC, comma, by the informant / wife and the accused / husband. Stop. This petition has been filed jointly by the informant and the accused on the ground that they have entered into a deed of mutual settlement on 28 October 2025, wherein it has been agreed that the complainant will not pursue the matter further, and that since August 2024, the parties being the informant and the accused are living together as husband and wife and have also registered their marriage before the marriage officer on 5th March 2025, and they have and that they have a daughter between them. They have a daughter who has been born to them. Stop. It has also been agreed in the settlement deed that the parties intend to withdraw the FIR dated 6/1/2020 under Itanagar Women PS case number 1/2020 under section 376/417 of the IPC in the interest of justice. Stop. This court has considered the submission of the learned counsel for the petitioners and also the learned PP who has no objection in the said matter, as this matter is purely related to a marital dispute between husband and wife. Stop. This court has also considered this fact and is of the view that that it would be a futile exercise to continue with the criminal proceedings in the present case, as it is a purely private matter between husband and wife and has arisen out of a marital dispute which has been mutually settled between the parties. Stop para. Accordingly, the petition is allowed and the FIR dated such and such, that you just quote the earlier one, okay? Dated such and such, in such and case such and such, is quashed and set aside. Quashed and set aside, petition stands disposed.
Much obliged.
Item number 6.
May I please, Lordship?
Yes. Bail.
Yes, my lord. This is a bail application in which one of the charges sections is under FOXO,
Hmm.
under section 12 for sending and
Arresting authorities at the time of arrest. And thereby the fundamental rights guaranteed to the accused person under Article 22(2) of the Constitution of India has been violated. Stop. Para. In view of this said above observation, comma, the accused person is hereby released on bail on the following terms and conditions. Dash number 1. The accused shall execute the bail bond of rupees 30,000 with one surety of like amount, who shall be a local government employee. To the satisfaction of the learned trial court. Number 2, the accused shall not leave the jurisdiction of the trial court without the leave of the court. Number 3, the accused shall not try to influence the witnesses in any manner and shall not try to influence the witnesses or try to contact the victim in any manner. Stop. Okay. So I think that will be shall not try to contact or influence the witnesses and shall not try to contact the victim in any manner whatsoever. Then next point, the accused shall appear before the trial court on every date as and when fixed by the court. So, with the above
my lord,
conditions.
a small prayer with regard to the surety of the government employees. Accused has no such relative. So can it be two surety? His wife as well as his brother will undertake to appear on every hearing that, my lord. My small
You don't have any
No.
relatives?
Yes, my lord, who are government employees in the Darfur region. Since the cases of Darfur region of Upper Subansiri and trial is going on at Sessions Court, Basar, at lower
Okay, two local sureties. Don't say government employee, two local sureties. Yes.
deeply obliged, my lord.
That matter is disposed.
Your Lordship,
Yes.
my sincere apology.
Huh.
Lordship, I beg to mention item number 21.
What happened? Why didn't you mention in the mention?
Lordship, Mr. Deepan has left the court due to some personal difficulties. So kindly this matter may fix on 27
Which item? Which item?
January. Lordship, 21. Item number 21.
When do you want?
Your Lordship, kindly this matter may be fixed on 27 January.
27.
Yes, Lordship.
General Counsel. You are for the appellant?
No, Lordship, I am for. Yes, Lordship.
Appellant. Mentioning on behalf of?
Deepangi.
General Counsel, Mr. Such and Such, makes a mention on behalf of the leading counsel, Mr. Deepangi, to list the matter on 27/1/2026 as the council has some difficulties today. So, learned the prayers allowed list on 27/1/2026 as prayed for. Yes.
I love Lordship.
Item number 7.
May it please, your lordship.
Lordship, this is an bail application.
Mm.
Today, Lordship, the accused was arrested on 21st October, and today is 92 days. And the instruction was given that charge sheet has not been filed till this date, Lordship.
Arrested when?
Yeah, 21st October 2025.
21/10/2025.
Seven. The offenses are Lordship 21B, 27A, and 29 of NDPS Act.
21/10/2025. So now, as on today, how many days is it?
92 days, Lord.
92. So you're saying he's entitled to default bail. Is it commercial quantity or is it intermediate quantity?
No, Lordship, this is actually
Hmm.
in the sampling order passed by the learned CGM, it is only 5 gram, which means it is a small quantity. But however, the investigation agency, they have mentioned it as a 21B, Lordship. I have
So 21B is intermediate.
intermediate. Yes, Lord.
Intermediate. Yes, PP. Is it 90 days or 180 days? Does it come under? 60 days. Intermediate.
Because 180 will be Lordship.
180 is commercial. It should be 90 days. Intermediate is 90 days. Yes. So they're saying it's 92 days and charge sheet has not been filed.
Yes.
We have no instruction, Lordship, for whether charge sheet has been filed or not.
I have taken the instruction just now
Hmm.
from the GR branch, Lordship.
Lordship, tomorrow, Lordship, I'll take instruction.
You are certain then? You are certain the correct position and then you either you get written instruction or verbal also, it's okay. Yes. Pass over for the day in order to enable the learned PP to obtain instructions regarding the status of the case, regarding the as to whether the charge sheet has been filed or not. Yes.
God bless.
Item number 8.
Lordship, may I?
Yes.
TCR has been called in this case.
It's charge sheeted.
Yes, yeah,
Charge sheeted case.
charge sheeted, and I was arrested due to the existence of non-available warrant only. That is the
No. What I mean is, if it's charge sheeted,
yes,
then
charge sheet.
we'll call from the court. Otherwise, BP will produce the CD. No, that's why I want to know.
Charge sheeted.
Okay. On last occasion, was it called?
Yep.
Okay. On 8/1/2026, this court had called for the scanned copy of the TCR stuff. However, the same has not been received till date.
Yeah.
The Learned Counsel for the petitioner, Mr. Sergeant
J may be.
present.
J may be.
Miss L. Age, Learned Additional PP is present for the state respondent stuff. Please the matter after 2 weeks. And the
Lordship, 2 week, it will be.
no, this is from where?
It's UP only.
Oh, okay. Then next week is the
Exact
matter.
particular.
Next week,
You're not 30.
30.
It's not par.
Let it be 29th.
Your Honor, my lord, what is happening due to this NVW only? NVW only, I have been detained. So it's been more than 7 months.
No. Since 30th is the last working day for this court, I'm just suggesting 29th.
29. Yes.
Just on 29/1/2026, so the registry shall issue a reminder to the learned trial court to transmit the records. So, yes.
Abhilash.
Item number 9.
Yes.
Yes, my lord. My lord, matter is sent to for a mediation, my lord. But somehow could
failed.
not, yeah,
Uh,
couldn't settle between the parties, and matter refers back to the owner.
and what about notice on the respondents?
Haven't completed, my lord.
Not completed.
Yes, my lord. Allow me to take fresh steps, my lord.
But they appeared before the mediation center.
Yes, my lord.
So which means they are aware, but you have not served them copies, maybe.
No.
Learned Counsel, Mr. Sergeant Such, appears for the appellant and submits that the matter was referred for mediation. However, the mediation was not successful, and therefore the matter has been referred back to the court. Stop. Para. Accordingly, list the matter after 3 weeks. Would you like to take steps then?
Yes, ma'am.
And the learned counsel for the petitioner shall take steps for service on the respondents by inland speed document within 3 working days from today. Yes.
Item number 11.
Relation. This one also records not received.
Yes, my lord. I am appearing on behalf of private respondent number 2, my lord, here in the matter.
Okay. Are you filing any objection?
No, my lord.
No.
So far.
What about petitioner?
Petitioner seems to be absent, so
None appears for the petitioner when the matter is called. Stop. Learned counsel, such and such. Your name
my lord N. Rama
and Rama
on behalf of
appears
respondent number 2.
for the respondent number 2, and the learned additional PP Ms. L. Nagi appears for the state respondents. So, the trial court records had been called by the order dated 4/9/2025. Stop. However, the same has not been received. Stop. Accordingly, list the matter after 3 weeks. In the meantime, the registry shall issue a reminder to the office of the Additional Deputy Commissioner Balijan
yes,
Papumpare district for transmitting the records of execution petition BJNPS non-FIR case number 2/2024. So, yes.
much. 3 weeks.
3 weeks.
Item number 12.
My service report is awaited, madam.
Service report.
Awaited.
Okay. Service report on
Respondent 1 and 2.
no, respondent 1 is the state. So it should be 2 only.
As per report, there is no any such remark.
This year as well as service report not yet received. Okay. Learned counsel for the petitioner, your name?
T-zone.
T-Son is present. Stop. Learned additional PP MS L Hagi appears for the state respondent number 1. Stop. The office note dated 19/1/2026 indicates that the trial court records as well as the service report in respect of respondent 2 has not been received. So accordingly, list the matter after 3 weeks, awaiting service report on respondent number 2. Stop. The registry shall also issue a reminder to the learned session judge 0 for transmission of the trial court records. Yes.
Much obliged.
Item number 13.
Yes, my lord. Here also find that service of the respondent, private respondent 2 is yet to be received. So
Fresh steps be taken through the jurisdictional. This is a POCSO matter.
no, my lord, this is a criminal petition filing for quashing of FIR, my lord.
Acha.
Section case section was registered.
Respondent 2 is the
Complainant.
informant.
Yes, my lord, informant.
The court has given a direction to take steps through the police station.
Concerned police station.
You have taken steps.
My lord, earlier I have taken, so my lord, I am allowed to take fresh step, my lord.
Because you are supposed to take fresh steps
Yes, ma'am.
through the registry to be routed to the concerned police station. Okay.
Yes, my lord.
Yes. Learned counsel for the petitioner, Mr.
N. Rama.
N. Rama is present. The learned additional PP, Ms. L. Lagi is present for the respondent number 1. Stop. By order dated 9/9/2025, this court had directed the petitioner to take fresh steps for service upon the respondent number 2 through the jurisdictional police station to be routed through the registry of this court. Stop. The same has not been done by the learned counsel for the petitioner. Stop. Accordingly, list the matter after 3 weeks, and the learned counsel for the petitioner shall take the fresh steps through the jurisdictional police station by routing the service through the registry of this court.
Yes.
The same shall be done within 3 working days
Yes, ma'am.
from today. Yes. List after 3
March.
weeks.
Item number 14.
Lordship, I'm appearing on behalf of Kigara for the petitioner. First, we may be allowed to take fresh steps for the respondent.
Relevant records not used to learned counsel for the petitioner, Mr. Your name?
On behalf of Kigara, Lordship.
No, but your name is Sergeant Search on behalf of
Kigara.
Kigara. Submits that prays that he may be allowed to take fresh steps for service on the respondent number 1 and 2, isn't it? Respondent number 1 and 2. Stop. Prayer is allowed. The trial court records have also not been received from the Deputy Commissioner, K. Panyor District. Yechuli. Okay. From the Deputy Commissioner, K. Panyor District, Arunachal Pradesh. Stop. Accordingly, the list the matter after 3 weeks. In the meantime, the petitioner shall take fresh steps for service on the respondent number 1 and 2 by inland speed document within 3 working days from today. So the registry shall also issue a reminder to the learned Deputy Commissioner, K. Panyor District, Yachuli, to transmit the trial court records. Yes.
Item number 15.
Yes.
May I please, Your Lordship? 15. For the petitioners, Your Lordship.
Service complete.
Your Lordship, with regard to one service is complete, they have appeared.
They have
filed
entered
their
appearance.
And with
Then-
regard to respondent number 2, there is no remark in the office note, Your Honor.
The appearance on behalf of 1. Can we proceed without 2? Otherwise, you have to take fresh steps.
Yes, Your Lordship, sure.
Huh.
Okay, for on behalf of the respondent number 1, 3.
1 and 2. This is item 15.
Yes.
Isn't it?
15 only.
So you'll enter appearance for both 1 and 2. Okay. Then it's
In that case,
learned counsel for the petitioner, Mr. Sergeant is present. Stop. Learned counsel, Mr. Chiki Sangma enters appearance for respondent number 1 and 2. You have filed vaklanama for both.
3 weeks maybe given to
And submits that he has filed vakalanama accordingly. Stop. Learned counsel prays for 3 weeks time to file an objection affidavit in the present petition. Prayer is allowed. List after.
Your Lordship, there is an interim order that may be continued.
List after 3 weeks. Stop. The interim order passed earlier shall continue till the next date. Yes. Will you need the trial court records? Is it required? This is what?
Your Lordship, it's an order passed by Gaon Board.
Oh, okay. Then there may be no records
Yes,
available.
Your Lordship.
Yes.
Hello.
Item number 16.
May I?
Yes.
This is joint petition, criminal petition. Earlier, interim and interim was granted by this honorable court. TCR was called. Only the issue was whether theft was committed. The theft committed Iron Road was of the property of government. Well, that was only the issue. This is 27 years old case.
Theft,
yes. Great. Actually, section according to police charge, this was 379. But honorable trial court had altered the case during the framing of charges and framed the charge in section 380 of the IPC. That is only. May I, my lord, may I take to page number 44?
44.
Yes, that question primarily answered. 44. Last 6th line, 44 and etc.
Yes.
This is the statement of complaint. Informant.
Okay.
May I?
Yes.
After I tried to go out from the main door, but the miscreant locked from the outside door and verified my road was kept in my home compound. During my verification, 3 bundles of 12 mm road Daya were purchased from the Naharlan supermarket 2023 has been stolen. This was his personal property. That is only the question.
After that, I forgot to mention.
And his informed statement is very clearly speaks. Even FIR also, my lord.
Where is the FIR?
FIR. Page 23. Yeah, similar, it has been repeated.
23.
Yes.
Some groups. Yes, please read.
With just I'm just coming to the main body of that in FIR. With reference to the subject cited above, I beg to inform you that today at 2:30 hours, some group of 5-6 people enter into the compound of my golf quarter. So this and this, Itanagar is stolen away 3 bundles numbering 23 pieces, 12 mm dia of iron rod, which was kept for my house construction. My house. So this is.
I came to know about the theft. I made me informed if it was recovered.
Though offense was committed as alleged in government quarter, but property was of the private.
Property was of the company.
Private, yes.
Private property.
And settlement copy is, my lord.
1 minute. So petitioner number 1, 2, 3 are the accused persons.
Yes.
And petitioner number 4 is the informant.
And settlement is page 123.
123.
Yes. Yes, he's 27 years old. It's
For,
covered by judgment
for
of
such a small matter, it's
Yes.
going on for how many years?
27 years.
Why was that? This date of settlement.
Matter was never brought before the trial court.
In such and such. And this was executed when? Last year,
Yes, yes.
25.
May 3rd,
Mm.
2020.
In such, against it before responsibility. Iron rod. Such. In that case, it is compoundable also, isn't it?
380 is not compounded. Honorable trial court has altered the charges from
Oh.
7
Mhm.
deaths.
Just compoundable. Just such a Pardon the second party on the trial. Okay, and what is the stage of the case?
It's on evidence stage.
Evidence stage.
Yes, yes. The prosecution. Not yet, since this honorable court has stopped the proceeding.
Okay, okay. The proceedings were stayed.
Yes.
Okay.
My lord, you know, we have catenary of such judgments. So anyhow,
Yes,
I'm
yes.
relying on
We'll
Lakshmi
close
Narayan.
it then.
Lex,
Yes.
Lakshmi Narayan case, my lord.
Yes, yes, ma'am.
So
It's okay, no
it's
problem.
okay.
Heard learned counsel for the petitioner, Mr.
Maybe.
Such also heard Miss L. Lucky to learn additional PP for the state respondents. Stop. Para. The present application has been filed under section 528 of the BNSS, praying for quashing of the proceedings, trial proceedings before the court of CJM UPIA, Papumpari district, in connection with Itanagar police station case number 72/98 under section 380/448/34 in connection with GR number 130 of 1998. So, this application has been filed jointly by the petitioner number 1, 2, and 3, who are the accused persons, and the petitioner number 4, who is the informant/complainant. Stop. Para. It is the case of the petitioner that an FIR was lodged on 7/6/1998 against the accused persons for allegedly stealing 3 bundles numbering 23 pieces of 12 mm iron rods, which was kept in the house of the informant/complainant for his house construction. Stop. The matter has been investigated and charge sheeted and is now pending trial before the court of CJM UPIA, Papumpari district. Stop. Para. It is further submitted by the learned counsel for the petitioners that the accused persons and the informant have entered into a deed of mutual settlement executed on 3rd May 2025, wherein it has been agreed that the parties have decided to settle the matter. Decided to settle the case, which has been registered as Itanagar Police Station case number 72 of 1998 under section 380/448/34 IPC. Stop. It has also been agreed between the parties that the informant had pardoned the accused persons in good faith and has decided to withdraw the Itanagar PS case number 72 of 98, which is under trial before the learned court of Chief Judicial Magistrate UPIA, Papumpari district. Stop. It has also been agreed between the parties that no further action will be taken by the informant, and that the case is settled between them outside the court. Stop. In view of the same, the petitioner prays that the pending case, being GR number 130 of 1998, be quashed and set aside in the interest of justice. Stop. Para. The court has considered the prayer of the petitioners and has also perused the trial court records. Stop. Learned PP. Learned additional PP appearing for the state respondent has no objections, as the parties have already settled the matter amicably outside the court. Stop. Considering the nature of the case and considering the fact that the accused persons as well as the petitioner have filed this petition jointly on the basis of the settlement deed arrived at between them on 3rd May 2025, this court is of the view that it would be a futile exercise to continue with the criminal proceedings in the court of the Chief Judicial Magistrate UPIA in GR number 130/1998, as there is no possibility of conviction. So accordingly, this petition is allowed and the proceedings in GR number 130/1998 pending before the Court of Chief Judicial Magistrate UPIA, Papumpari District is quashed and set aside. This petition stands allowed. The registry shall send back the trial court records.
Item number 17.
My lord, I have become infractious, my lord, so allow me to withdraw it.
Okay. Learned counsel for the petitioner, Mr. Lolan.
The other man.
The law submits that the IA has become infractious and he prays that he may be allowed to withdraw the same. Stop.
And my service subpoena respondent number 2 already completed, my lord, but till today he is not.
Wait, let us first finish this.
Okay.
What did I say last line? Withdraw the same. Stop. Prayer is allowed. The IA is disposed of and being withdrawn. Then the main petition, in the main petition, criminal petition, you say, Mr. Sergeant Serge appears for the petitioner and Ms. El Hagi appears for the state respondent. So what did you say? Service report?
Service report upon respondent number 2 completed, man.
Completed?
Yes, man. But till today he is not appearing before this court.
Service is stacked with reports. It says respondent was not available at his residence. Hence, the notice of petition was received by Mr. Such and Such, younger brother of the respondent. It was not received by him personally. It was received by his younger brother. Maybe you should take steps by Dusty. Is it possible? Dusty service?
Service.
Oh, it's a criminal case. Yes, yes.
It is completed on 18/12. Maybe that's how.
Let's wait. Give one more chance.
Then, my lord, matter may be fixed on 30 of this month.
Because this was received only in December, last year, December 17. Okay. Learned counsel for the petitioner, Mr. Sanisach, and also learned additional PP, Ms. L. Hagi for the state respondent. Stop. The service report in respect of respondent number 2 has been received by the brother of the respondent. Stop. Today, when the matter is called, none appears for the respondent number 2. Accordingly, list the matter when?
30 of this month.
Let it be February first week.
No, my senior counsel instructed me to fix the matter on 30 of this month.
No, because we have to give some time at least, no, for the respondent. Okay, let's see on 30 then.
And
Yes,
my lord, updated CD was directed to
be produced.
before this call, Your Honor.
This is the matter on 31, 2026, awaiting the appearance of respondent number 2. Stop. Further, the learned APP shall also produce updated copy of the CD on the next date.
Much.
Item number 18.
Lordship, service has not been completed. For respondent number 2.
Respondent 2. Learned counsel for the petitioner, Mr. Your name? Question sir is present. Stop. Learned additional PP, MSL and is present. Stop. Office note dated 19/1/2026 indicates that service report in respect of respondent number 2 is not yet received. Stop. Accordingly, list the matter of the 3 weeks awaiting return of service on the respondent number 2. Yes.
Item number 19.
May it please Your Honor, Lordship. Lordship, I'm appearing on behalf of Mr. K. Posi for the petitioner. Lordship, the service report shows that the service upon the respondents is incomplete.
1 and 2.
Read that. I may be allowed to take fresh steps and still then the interim order passed by this honorable court may be continued.
This is okay. You're praying on behalf of
petitioner on behalf of Mr. K. Posi for the petitioner.
okay, K. Posi.
Yes.
Learned counsel, Ms. Such and Such, appearing on behalf of Mr. K. Posi for the petitioner, submits that the service report in respect of R1 and 2 is not yet received. Stop. Accordingly, list the matter after 3 weeks awaiting service report on the respondent number 1 and 2. So till the next reasonable date, the interim order passed earlier shall be extended, shall stand extended. Yes. List after 3 weeks. Huh?
Item number 22.
22.
My lord, here I'm appearing for the revision petitioner, my lord. This has come up for final hearing, my lord.
Against Kaba decision.
No Kraba decision, my lord. Here I'm challenging the order of the additional deputy commissioner, ma'am, to which, in my understanding, has been passed without any jurisdiction, my lord. Before taking a lordship to the relevant annexers, my lord.
Will the trial court records be required?
No, my lord.
Not required.
No, my lord. There is only one order of the additional deputy commissioner, my lord, which has been put to challenge.
Which you are challenging.
My lord.
Okay. Yes.
Yes, my lord.
1 minute, 1 minute.
Yes, I prepared a list of dates, my lord. The facts, my lord, here is that initially, otherwise this petitioner and the respondent, my lord, they are the mother and son, my lord. after the death of the father, my lord.
Okay, the respondent who's appearing for the respondent. Okay, sole respondent.
Soldiers.
Mm.
Now, my lord, there was some dispute, my lord, regarding some building, my lord.
Mm.
So accordingly, a Kaba was held.
Mm.
Now, Kaba decided that partition was done, my lord, between the petitioner and the respondent. My lord.
Mm.
Now, that Kaba was
Regarding some property.
yes,
Mm.
regarding one particular building, my lord.
Mm. Mm.
It's a commercial building. No?
Mm.
Now, the respondent did not challenge that Kaba decision.
Mm.
And after that, my lord, in fact, what the respondent did,
Mm.
he filed a letter of administration case before the district judge.
Mm.
Now, my lord knows that once the title has been decided, my lord, letter of administration case otherwise will not lie, man. Now, since the respondent, my lord, in terms of did not comply with the Kaba decision, my lord,
Mm.
the respondent was not allowing me to collect the rent of my share of the building, man. That was given to me. I lost another complaint, man, before the Kaba, saying that I'm not being allowed to collect the rent.
Mm.
Now the Kaba issued a parwana to the respondent saying that you appear. Now that parwana was put to challenge again in the same LA case, later administration case, my lord, before the district judge.
Mm.
Now district judge ex parte, my lord, stayed the parwana.
Mm.
Now that parwana, that order of the district judge staying the Kaba, my lord,
Mm. Mm.
second Kaba, that is, was put to challenge by the petitioner.
Before?
Before this honorable
Before
court.
this court. Oh.
Yes, ma'am. Once CRP was filed, ma'am.
Mm.
Now that CRP was allowed by this honorable court, saying that since the respondent did not challenge the first Kaba, the Kaba has attained full finality. And the second Kaba is something different. It's regarding the rent. There's a new cause of action. But otherwise, the first Kaba has attained its finality and it should be implemented in its full vigor. That was what was done, ma'am. That our CRP was allowed and then the second Kaba was allowed to be gone ahead, ma'am. The second Kaba also reiterated almost the same thing, my lord, that the petitioner should be allowed to collect the rent. Now, in the meantime, what happened, my lord? This Kaba, my lord, the decision of the Kaba, it is to be executed by the assistant commissioner and the deputy commissioner, my lord, under the AFR, my lord. Now, this petitioner had, my lord, filed an application for execution, my lord, before the assistant commissioner. The assistant commissioner did not say anything, just disposed of the application, saying that comply with the order of the Kaba. That was only said, ma'am. Now, after that, subsequently, what happened, ma'am? The LA appeal, ma'am, or the LA case, letter of administration case, was before the district judge, was also dismissed by the district judge, saying that the High Court has also said the Kaba has attained finality, and once it has been decided, there is no need of going into the LA case. And secondly, the district judge also said the petitioner, the respondent here in my lord, has not come with clean hands. On those grounds, it was dismissed, ma'am. Now, against that order, the respondent filed a CRP again, ma'am, praying for
against the district judge order.
Yes, district judge order, and the order of the first Kaba, my lord, challenging the first Kaba also, my lord.
Oh, cha.
Yes, the first Kaba whereby the building was partition was done.
Yes, yes.
Now, in that CRP, prayer was also sought for for staying the execution order passed by assistant commissioner. The assistant commissioner, this honorable court did not grant any interim order. Now, what the conduct of the respondent, what she did, she went to the additional deputy commissioner, filed there an application. After this honorable court declined to grant any interim order, went there and before they filed an order, in fact saying that even after the order of this honorable court has said the Kaba has attained finality, the first Kaba. Goes back to the additional deputy commissioner and says that Kaba was not as per law. But they did not put to challenge the order passed by this honorable court. And now that the ADC, what she did,
that CRP was disposed of
in the favor of the petitioner.
In favor of the petitioner.
Yes, in fact, observation has made that first Kaba has attained finality since no one has challenged it. Now the ADC, what she did, she doesn't have any power to review, man. the order already passed, my lord, the execution order. And but say automatically in mechanical manner, in spite of the order of this honorable court, state the execution proceeding, saying that only on the ground that there are so many litigations pending, my lord, which is not sustainable. That is my basic case, my lord.
Okay.
Now, my lord, I will take your lordship to first
And it is between mother and son.
mother and son.
Very unfortunate.
Very unfortunate, of course, my lord.
And so much,
We have also tried, my lord,
much
but
litigation.
yes, my lord. Now, if
Was
you-
it sent for mediation during that mediation drive? This case?
to there, my learned brother, of course, did not concede to it, but otherwise, opportunity was given in the first CRP file before this honorable court, my lord. There, we could not come to any settlement, my lord.
Settlement.
We also tried. Gave our suggestions also. This court also was pleased to.
This type of cases,
Yes,
no,
my
it
lord.
is good if mediation can be done. So
My lord. My lord, I will take your lordship to the first Kaba decision. It is at page 29, my lord. Page 29, my lord. And this is in the local language. Next, page 30 is the translated one, my lord.
yes.
Translated copy, my lord. This is a Kaba decision, man. On dated 8/7/2023, Srimati so-and-so, wife of so-and-so, who is the petitioner, my lord, has submitted a complaint before Union Clan on 2 grounds. The soaps that my late father-in-law had given is not being handed over by mother-in-law, Srimati so-and-so, who is the respondent, my lord. That the thatched kitchen was built by Sri so-and-so, the petitioner. Today, on dated 16/7/2023, under the chairmanship of Sri Hendak Jini GB at the residence of Sri so-and-so, son of so-and-so, the Jini clans on adjudication of the above complaint has given the following decision. In regard to point number 2 of the complaint, it is hereby decided that the thatched kitchen shall be given to Sri so-and-so in memory of the late so-and-so. This Sri Yomdak Jini is my younger brother, my lord. That was given, man. And regarding the first, my lord, that the commercial building, in regard to point number 1 of the complaint, with regard to partition of the commercial building, the order is passed as such. The partition shall be as per the partition made by the deceased father. It is hereby passed that partition, the upper part of the partition building shall be passed in favor of Srimati Dongam Jini, the respondent, my lord. And the lower portion, part of the partition building is passed in favor of Sri Yamto Jini, my lord, that, the petitioner. So that building was, partition was done, my lord, by that Kaba, my lord.
So upper part was given to the respondent and the lower part was given to the petitioner.
My lord.
Okay.
So if my lord will come to the list of this that I have provided, my lord. So my lord, date is the 16/7/2023 is the first Kaba, my lord. And after that, that Kaba order was not challenged, my lord. On 26/7/2023, letter of administration case was filed by the respondent before the district judge, Aloman. We were not aware of that, the petitioner, my lord. Now that second complaint was made. The second complaint, that is on 28/2023 and 5/9/2023, that Parwana for second Kaba was issued for settlement of dispute regarding collection of rent. Now on 9/10/2023, second Kaba stayed by district judge Alom. This was put to challenge in the CRP 61 of 2023. Now, my lord, I will take your lordship to that judgment of this honorable court, my lord. It is at page 32.
CRP 61, 2023. Yes.
Page 32. My lord, I will take your lordship to the relevant portion, my lord. That page 36, my lord. Para 11, my
Yes.
The perusal of the aforesaid regulation shows that the village authorities is competent to decide the dispute between the parties, being both indigenous to the state of Arunachal. Further, under the aforesaid regulation 24, a decision of the village authority is appealable. In the present case, admittedly, no appeal has been filed against the decision of the village authority dated 16/7/2023. The Kaba decision dated 16/7/2023, having not appealed within the stipulated period, has attained finality and therefore cannot be reopened. However, it appears that against the same plot of land, the letters of administration has been sought for by filing the connected LA proceedings. Here, my lord, the Honorable Court has given its observation that the Kaba decision has attained finality. Now, at page 37, next,
Okay. Yes.
the first Kaba has attained finality. Paragraph, my lord, I will take your lordship directly to paragraph 35 to 15, my lord.
15.
15, my lord. A perusal of the impugned order dated 9/10/2023 passed by the trial judge indicates that by an interim order, the Kaba Parwana dated 5/9/2023 issued by the in-charge head Gangapura of Alo has been suspended until further order. The interim orders are not to be given merely for the asking. The order dated 9/10/2023 does not indicate any application of mine whatsoever for staying the subject Kaba Parwana. As discussed above, the subject plot of land having already been settled by Kaba proceedings dated 16/7/2023, the same is required to be carried out in full spirit. However, it appears that because the respondent did not allow the petitioner to collect rent from the shops falling under his partition portion, subject Kaba Parwana was issued. Hence, the ex parte order dated 9/10/2023 suspending the said Kaba Parwana dated 5/9/2023 in the LA proceedings in respect to the same land is manifestly erroneous and has occasioned grave injustice. Therefore, the impugned order is bad in law and hence unsustainable. What I wanted to show, my lord, here is that this court has come to the finding that Kaba, the first Kaba has
First Kaba is final.
yes attained finality. There has been no challenge to that Kaba, nothing, my lord. So it has attained finality, my lord. Now, after that, my lord, this second Kaba was that after the direction of this court, my lord. That second Kaba was also held, my lord.
Yes.
Page 39, my lord. This is also in local dialect, my lord. The translated copy is at page 40, my lord.
This is dated
29 June 2024.
29/6. 29/6/24.
My lord, after the dishonorable judgment of dishonorable court, my lord.
So what does it say?
Today on dated 29 June 2024 at the Hiko Lower Hall, the case between Sri Yomto Jini and Srimati Dongam Jini in regard to the commercial building is taken up under the chairmanship of Sri Orkan Jini GB and the Kaba had passed the order. As per the decision pronounced in Jini Kaba held on 16/7/2023 in regard to the commercial building of plot 4, 2 plot of the shop of Sharma Electrical was passed in favor of Srimati so-and-so, the respondent, my lord. The plot of Savir Garage was passed in favor of Sri Yomto Jini while modifying the existing entrance road by Jini Clan Kaw in favor of Sri Yomto Jini. It is passed that the same shall be kept as family entrance. As passed earlier, whereby the top floor, which was equally divided, is upheld herein. As such, the parties shall collect the shop rents from the ground floor to top floor as per the decision passed henceforth. Basically, it says that Kaba has already decided that earlier Kaba. So one should be allowed to collect the rent.
According to that, the rent
Yes, the rent should be collected.
per that first Kaba.
Yes, that first Kaba.
Yes, then.
Yes, my lord. Next is, my lord, the order of the district judge, my lord. at page 41, my lord. This is by which the letter administration case was dismissed, my lord.
Order dated. This is
7/8/2024.
7/8/2024.
24, my lord. This was dismissed, my lord. I will not go into it, my lord. On the ground that the High Court has also said the Kaba has attained finality and it should be given its full vigor, my lord. The operation of that Kaba decision, first Kaba decision, my lord. Now, my lord, what happened, my lord? During this pendency of the first CRP, my lord, this the petitioner had approached the Assistant Commissioner, my lord, for execution, my lord. That order is at page 45, my lord. Annexure 7, my lord.
During the pendency of CRP 61.
Yes, CRP 61, my lord.
Yes.
Dated Alo the 31/1/2024, my lord.
Yes.
My lord is there. It's to the respondent, to Srimati Dongam Jini, the respondent, man. Whereas a petition has been received from Sri Yongto Jini, the petitioner here in Mal, son of so-and-so, Sipu Colony near Yombu Hotel, Alo, West Siang District, in which it is stated that you have not complied with the Kaba decision of 16/7/2023 in connection with the property dispute pertaining to the commercial plot building of late Rayam Jini located at Old Market, Alo West. Therefore, you are hereby directed to comply with the Kaba decision of so-and-so with immediate effect, failing which necessary legal action shall be initiated against you as per law. Nothing, just it says you comply.
To comply.
Nothing else, nothing. Now, what happened, my lord? If your lordship would come to the list of that again, my lord. It's a 29/6, my lord. After that, my lord, before that, my lord, 12/6, my lord, CRP 21 of 2024 was filed by the respondent challenging the first Kaba order dated 16/7/2023 and the execution order dated 31/1/2024, my lord. Here, my lord, interim prayer was made, my lord, for staying the first Kaba as well as the execution order, my lord, of this 31/1/2024, my lord. This court declined, my lord. Now, when this court...
Where is that? 21, CRP 21 order? Have you enclosed?
No, my lord, that I have not enclosed, my lord. There was nothing was said, my lord. Initially, that only, subsequently it was withdrawn, my lord. Withdrawn, my lord. Now, I'm just trying to show the conduct of the respondent, my lord. How it is playing with this court, my lord. Now, on this 12/6/2024, it was filed. And CRP 21 of 24, when interim prayer was made, my lord, interim was granted. What happened, my lord? Next state is said 24/6/2024, immediately after that interim prayer was not, he goes back to the additional deputy commissioner and files an application for recalling of the order of the 31/1/2024, my lord. It is at Annexure 8, my lord, page 46, the application, my lord.
Praying for recall of the order dated 31/1.
Yes, 31/1/2024. This is after this honorable court refused to give any interim order. How the respondent is, my lord, playing hide and seek with, my lord, this honorable court, my lord. Now here this application was made, my lord.
This is filed before ADC.
Yes, my lord, before the ADC, my lord. And in fact, my lord has seen, my lord, the CRP 61 order, my lord. This court says that Kaba has attained finality. But in this entire application, my lord, it basically says that that Kaba was non-est, in fact challenging the validity of the Kaba order itself. But what is pertinent here is that they did not challenge the order of this honorable court that was passed in 61, my lord, whereby this honorable court said that the Kaba has attained finality, Kaba order, my lord. Now, after that, my lord, this application was filed, my lord. The impugn order has been passed, my lord.
CRP 61 was order dated CRP 61 was disposed of when?
29/4/2024, man.
Oh, okay.
29/4/2024, it was disposed, man. It is everything is after this the order passed.
After that
Yes,
order of CRP 61.
Yes, ma'am. Now, after this, in pursuant to that application, this impugn order has been passed, which is at Annexure 1, page 15, ma'am.
Page 15.
Page 15, yes, ma'am.
Yes. Let us see.
This is yes, impugned, my lord. The perused application filed by Sri Yamtojini on dated 14 of praying this court of admission examination and passing of so and so passed by the village authorities, my lord. That is passed by the village authorities in clan on in the matter of intellectual property dispute arising between Sri so and so. Accordingly, Srimati Dongam Jini, the respondent, my lord, was ordered to comply the impugned decision passed by the village authorities on dated 16/7/2023, by this court order number so and so dated 31/1/2024, my lord. Sri Yomto Jini used the decree holder in this case informed to this court that the execution order issued to Srimati Dongam Jini White so and so is not complied by the former till the month of July 2024. This court on dated 16/7 summoned both the parties to appear on 5/8/2024. Parties appeared on 5/8/2024 at 10:30 hours. Both parties are heard in length. In the meantime, Srimati Dongam Jini produced documents like appeal petition filed before the Honorable Court of District and Session Judge Alo High Court on dated 26/7/2023, respectively, with an information that the instant case is sub judice in other court. All documents produced by Srimati Dongam Jini has been cross-checked, verified, and advised her to submit one copy of it to the DC office Alo. Gone through the case file, case records, and documents, and it is found that 1. Srimati Dongam Jini filed a revision petition bearing CRP 21 and 24. My lord will say this. Here, my lord, no entry was granted, and it was subsequently withdrawn on 17/9/2024. That I have stated in the list of dates. Wherein this the matter will be listed after 3 weeks. Number 2, it is also found that Srimati Dongam Jini filed a letter of administration before the court of the Honorable District and Session Judge Alo on dated 26/7/2023, which is pending disposal. Now, it is crystal clear from the records that the instant case is sub judice in the other court or other appropriate forums, and hence the execution order notice to Srimati Dongam Jini White number so and so dated 31/1/2024 is hereby called back forthwith, which I am putting to challenge. My lord will see. It doesn't say anything, my lord, nothing. Just because matters are pending, my lord. In spite of this honorable court's order saying that the Kaaba has attained finality, it should be given the operation of the order of the Kaaba. It should be given its full vigor, my lord. The operation of the order, my lord. Now, in a very mechanical manner, she says there are many matters pending. So we will state it.
What matters were pending? Only the LA application.
LA application, yes. LA application was a different issue, my lord. And then that CRP was filed, my lord. CRP was
LA
pending.
application was regarding
Regarding the only for administration, letter of administration, my lord. There, in fact, in that LA case, my lord, what happened, it was portrayed as if the husband and the father of the petitioner and the husband of the respondent has died intestate, so I may be allowed to administer the property. However, this district judge, of course, I've taken your lordship.
Before passing this order, review order, were you heard?
Yes, I was heard. I was heard.
Then you did not produce a copy of this CRP order.
Produced. Everything was produced, my lord. But otherwise also, can this be a ground, my lord? And one more thing, my lord. Other than this, my lord. Firstly, this cannot be a reason to stay, my lord. The execution order, my lord. And basically what happens is that this amounts to review, my lord, of the order, my lord, earlier passed, which the executing court doesn't have, my lord. My lord knows that power of review, it comes from statute. It cannot be an inherent power, man. So AFR doesn't provide for that, man. So this cannot be done in such a manner, man. And my lord will see the conduct, my lord, of the respondent itself. Here in this CRP also, the affidavit has been filed, alleging the same thing, that no Kaaba was there. Kaaba, the first Kaaba, my lord, it is no Kaaba, it is known as, whereas they did not challenge the order of this honorable court passed in CRP 61 of 2023, my lord. And when this honorable,
this execution petition was filed for execution of that first Kaaba.
First Kaaba only. LA case is different, my lord.
Yes.
Only issue was regarding that pending at that time was the CRP 21 of 2024, my lord, which was filed after the first CRP
And
61.
where no interim order was
No interim order. And subsequently, what happened when this order was passed, they withdrew the CRP on 17/9/2024. That is how the conduct has been.
withdrawn on
17/9/2024. After this, after they got this order, my lord. That is how they are playing with the, my lord, administration of justice, my lord. Now, if your lordship would, I have annexed the AFR also, my lord. The relevant regarding the execution, my lord. It is at page 26, my lord.
Page 26.
26, my lord.
Yes.
Page 26, my lord. 45, my lord. 2, my lord. It's execution, my lord.
This is from extract from where?
This is the AFR, my lord, Assam Frontier Regulation. It starts at page 17, my lord.
Of Justice Regulation.
Yes, my lord.
Okay.
This is how, my lord, the village authorities are appointed under this regulation. The execution part is at regulation 45, my lord.
45
2, my lord.
Yes.
Execution and enforcement of the order or decree passed by the village authority. If the person against whom a decree or order has been passed by the village authority fails to pay or comply with such order or decree within a period of 30 days, the party in whose favor such decree or order has been passed may apply to the concerned deputy commissioner or assistant commissioner, as the case may be, for execution or enforcement of the decree or order of the village authority. The concerned deputy commissioner or assistant commissioner, as the case may be, on receipt of such application may call for the records of the order or decree of the village authority and execute or enforce the same by following the principles laid down in the CPC 99 in spirit. This is it, my lord. So there is no power of review, my lord. It cannot be done like that, my lord. This is, yeah. ये जो है ये लोग नहीं Amendment Act 2022. This is inserted 45(2).
45 Rule 45 2A and
2A, man. So my basic case, my lord, here is that when this honorable court has passed an order, and there cannot be any order that is in contempt of this honorable court. This is in fact amounts to challenging the majesty of the order passed by this honorable court, and that cannot be a ground that the LA case is pending, CRP is pending. We will recall. That power is not there before for the magistrate, my lord, to pass such an order, and this amounts to reviewing its own order, my lord, which is not permissible under law, my lord. That is my basic case, my lord. For that, my lord, just relying on this one judgment, my lord.
1 minute 31 page 46. This recalling petition was filed by the respondent praying for recall of this Annexure 7, isn't it? Page 45.
Yes, my lord. Annexure 7, my lord. Page 45, my lord. And otherwise also it is only said, my lord, in this that you comply with the Kaba decision, my lord.
Nothing, no coercive order was passed.
My lord, nothing, my lord. You only comply, my lord.
Just saying to comply.
Yes, my lord. And this honorable court has said the Kaba, which has attained finality, its operation should be in its full vigor. Now, can such orders be passed by the Commissioner, my lord,
Yes, what
in
does the
contempt of that
judgment
order?
say?
Which, this is, my lord, 2010, volume 9, SCC 437, my lord. This is on the issue that review, my lord, which the ADC has done, my lord. It cannot be done until and unless the statute provides for it, my lord. So, my lord, will come to page 445, my lord, at paragraph 12, my lord.
445, yes.
Just I will read this through paragraph 12 onwards, my lord. Legal issues, my lord. Review in absence of statutory provisions, my lord. It is settled legal proposition that unless the statute rules so permit, the review application is not maintainable in case of judicial, quasi-judicial orders. In absence of, here, my lord, they are exercising quasi-judicial or, my lord, power, my lord. In the absence of any provision in the Act granting an express power of review, it is manifest that an review could not be made, and the order in review, if passed, is ultra vires, illegal, and without jurisdiction, my lord. Next, paragraph 13, my lord. In so and so, my lord, I will not read this. This court held that the power to review is not an inherent power. It must be conferred by law, either expressly, specifically, or by necessary implication, and in absence of any provisions in the Act, rules, review of an earlier order is impermissible, as review is a creation of statute. Jurisdiction of review can be derived only from the statute, and thus any order of review in the absence of any statutory provision for the same is a nullity, being without jurisdiction. Thus, therefore, in view of the above, the law on the point can be summarized to the effect that in the absence of any statutory provision providing for review, entertaining an application for review, or under the garb of clarification, modification, correction is not permissible. So that is what has been done here in this instant case. They have no powers as such to recall, review, my lord, that any order, my lord.
Executing court cannot review its own order. Right?
Yes, my lord. It has to be expressly provided in the Act or the statute, my lord. This AFR, under which the ADC and the DC, my lord, they derive the power to execute the orders passed by the village authorities. It does not provide for anything, my lord. And otherwise also, my lord, just because there are some matters pending, my lord, it cannot be a ground, my lord, for staying the order, my lord. Or otherwise also this execution order, it doesn't say, you comply, basically that's it, which the High Court, this Honorable Court has also said, my lord. It should be given its full effect, my lord. And the conduct, my lord, that how the respondent is behaving, my lord. That is my basically. So I'm praying, my lord, that order needs to be quashed and set aside, my lord. I mean, not subject to what my friend says, my lord. I will reply, my lord.
Yes.
My lord, firstly, the said property in dispute, it's a government allotted land to my husband. And during his lifetime, there was no issue. I was collecting the rent. I was acting as the owner. That time, my daughter-in-law has no problem with that. Who made the complaint? After the demise of my husband.
But the first Kaba order, you have not appealed against that. You have not preferred any
That,
appeal.
Your Honor, if we see the order, it's a, at phase number, at phase number, in my service copy, there is no phase number, Your Honor, that's why.
Right. That was
Extremely sorry, my lord. Yeah, so
page 30.
79.
Page 30. Translated copies, page 30.
34.
Kaba order. What's the Kaba order?
No, no, come now.
First
Your Honor, if
Kaba.
we come to page number, yeah, page of it, High Court order, CRP 61. Actually, page, no, it is.
In my copy, it is page 30. First Kaba order, I think.
No, not Kaba order, High Court order.
Oh, High Court
Since
order. CRP.
Since my lord was asking why I didn't.
That is 32.
As far as my lord, my humble
Page 32.
understanding. Paragraph 11, page number 36. It is not a ratio decidendi. It's a obiter dicta. Observation made by the court, which is not binding. If we read the paragraph 11.
11.
Yes. As far as my
No.
humble
The
understanding.
court has clearly stated that the Kaba decision
Your
such
Honor,
and
that's
such
what.
having not appealed within the stipulated period has attained finality.
Yes, my lord.
Yes.
I say this is
How
not the
can
actual
that,
presidency.
how can that
This
be
is
a
just an
obiter
obiter
dicta?
dicta. Observation made by the court, which is not binding.
It is not an observation. It is,
Fine.
it has said that the court has clearly said it cannot be reopened. How can this be obiter dicta?
No, to my humble understanding, I thought this is an obiter dicta. That's why we didn't appeal this.
No,
More so,
obiter
coming
dicta
back.
means just by way of mentioning. But here, court has clearly said cannot be reopened.
May I read?
Yes,
paragraph
okay.
11?
Anyway.
The fair use of the aforesaid regulations shows that the village authorities is competent to decide a dispute between parties being both the indigenous to the state of Arunachal Pradesh. But under the aforesaid regulation 24, a decision of the village authority is appealable. In the present case, admittedly, no appeal. My lord, here also, section 24 is for criminal proceedings. However, this is a civil proceedings. Therefore, this section doesn't apply to me. May I kindly show your
No, but there must be some provision for civil proceedings.
in AFR, 24 is for criminal proceedings. Civil proceeding is different. There is only 2 chapters.
But still then, it still remains that you have not filed any appeal.
That is why,
Maybe
my,
court
lord, my
may have,
understanding was
court
this
may
is
have
just the
made some
obiter
mistake
dicta.
regarding the rule.
Just the observation made by the court, therefore not required to be appealed.
Okay, anyway, that is your submission.
Yes.
Yes.
Number 2,
Wait.
you know, if we come back to the first cover decision.
Decision in para
At annexure
P61.
1, phrase number 15.
Cover decision 29.
Oh, 29 है क्या? 15. That's what.
Yes. Then.
My lord, may kindly come to page 29 and excerpt 3, first cover.
Page 29.
And
yes, page 30 is the translated.
Third number is
Second cover 29, 39.
39. No?
Sorry, wait.
My lord, if we see the first cover and second cover, that is page number 39 and page number 29, parties are same, subject matter is same.
Yes.
Number 1, my lord, the thing my lord has to know. First, this is junior cover decision. What happens when my daughter-in-law made a complaint to the head Gaumbura? Head Gaumbura, what he did was, in spite of conducting cover, he advised us to solve amicably within family. Therefore, at my house, the meeting was conducted at my house. Generally, when kava is conducted, it should be at the general general community hall, and proper chairman should be appointed. All the Gauburas has to be there, witnesses has to be there. We have to present our own speakers and all. Or there are procedures, but this kava is conducted at my house as a family settlement. This is not a kava. Therefore, we didn't agree to this. Moreover, my son, he didn't attended on that cover. This present appellant, petitioner, he didn't attend this cover. My daughter-in-law was there, and all the family members were there, and we decided that we just try to solve it. I said no. During my husband's lifetime, she didn't make any complaint. After my husband demise, how can she claim? Therefore, I didn't agree to the family settlement, and I didn't put my signature. Thereafter, sensing the poll play, I filed the LA application after 4 days. That decision was not taken, no written, nothing. But after filing of the LA, I got the decision copy, which was placed at my shop, not even served to me personally. Therefore, the district court's order in LA that I have not come with a clean hand was that I didn't make any advertisements with regard to the family decisions. That I agree. But that was not a cover decision as far as my understanding is concerned, because this is not envisaged under AFR, neither under Arunachal Pradesh Civil Courts Act. This is not cover at all. Therefore, my lord.
But all this GB and all were there?
No GB, only 1 GB, that is my son. He was also a Kaba member. He is only one Gaumbura. He is my son, Yomdak Junior, Kendak Junior. He is my son in relation. It's a family, totally family settlement. If my lord see the attendance, all are my family. No Gaumburas, no head Gaumbura, nothing. It's a family meeting, no cover. Therefore, I didn't make any appeal against this decision. However, after CRP order, when paragraph 11 observation was made that this was a cover. There, then I appeal against that cover decision. However, I was delayed, so my delay was not condoned. For that, regular second appeal is pending here. Number one, my lord. Number two, my lord.
Oh, Chacha, okay. So CRP 21 of 24 was against this Kaba decision.
Yeah.
First Kaba decision.
When interim order first in LA application was challenged in CRP 61, then there was some observation by the court. No, that was different. Then, my lord, this order was passed where Kaba was ordered. Actually, the challenge was for staying the Kaba, holding of Kaba by the Sessions Court. However, this court has traveled beyond what had not been pleaded. In any case, that has not been appealed. But on the understanding that this was just an obiter dicta, just observation made by the court. Then, my lord, what happened? After this, they realized that this was not Kaba. So they went to Headgam, making another complaint. On the pretext that I am not allowing to collect the rent. Whereas, as per Arunachal Pradesh Civil Court Act, he has to make execution petition before Deputy Commissioner. That has already been made. This order where recall has been made, the order challenging in CRP. They have set into motion two forums. One before Head Gambura, on the pretext that my rent, I am not allowing to collect rent, making complaint in the form of execution petition, and another at the Deputy Commissioner filing an execution petition. They have made the two forum into motion, set the two forum into motion. That is how they have conducted this case. Therefore, which was stayed in LA application, which the CRP clarified, thereafter Kaba conducted. In the page, at phase 39, second Kaba,
yes,
same decision was taken. So, my humble submission is, as per this decision.
So, according to you, second Kappa is a proper Kaba.
It's a proper Kaba. It is the real proper Kaba, as envisaged in FR and APCC.
So, here also.
This also I have appealed. It is pending there at lower court, CJM court. Against this also, second Kaba also I have made appeal. This is pending. So what my submission is, the 29-6 Kaba decision has superseded the earlier family decisions. Therefore, all this, what has happened after that has become, null and void. I mean, it's infructuous. Therefore, even this CRP is not maintainable now. Because the base has been removed, now the superstructure has to fall. Because the second Kaba decision has already superseded the first family decision. Thereafter, my lord, as my lord was inquiring whether any mediation was, this court had once on occasion advised us to have a family discussion solved within the family and given us a 45 days of time. But before 45, that time granted by this honorable court, they file execution petition, they file another Kaba. That's why this couldn't be worked out, the amicable settlement.
Otherwise, it's between family and you're going to
basically
you're going to be living together, and the building also you're going to be sharing.
Building is just a rent, it's a shop.
Throughout your lifetime.
Yes. No, Your Honor, the fact is, my husband married, he is a first wife. There was no offspring. Therefore, this present my son was adopted. He's a son of his elder brother who has been adopted, not exactly adopted. In our Galo, we used to name our child after father. Like, my name is Mepa, my son will be Mepa Perli Liga. Like, we plot our name like that.
Wow.
So, he has been named after my husband, not exactly adopted. So, actually, my son is not interested in this case. However, my daughter-in-law, he is insisting on this thing. And during the lifetime of my husband, there was no issue. I was collecting rent. I was the owner. After death of my husband, this issue cropped up. Otherwise, maximum of the property they have got. Just for information, Your Honor. This. So, Your Honor, what my submission is, second Kaba decision, this is the proper Kaba decision, has superseded the earlier Jini family decision. Therefore, whatever happened after that, all gone. Even this CRP is not maintainable as far as this is my submission. Because when the base is removed, superstructure bound to fall. Moreover, what my senior colleagues have submitted, my application at phase number recalling application 46. Your Honor, my senior colleagues has misconceived. I have not filed for review of the order. I have filed for recalling. My application clearly says recall. Kindly recall the order.
But in effect, it is a review.
Not reviewing exactly. He has just called back his order. Nothing, no changes. Just call back the execution order. That's it. Saying that all these cases are pending. I'm making a appeal to the first cover, second cover also. First cover I was delayed. And I withdraw my CRP 21 because...
But in CRP 21, there was no interim order.
Yes, no interim order. But the court verbally advised me that you have a proper forum. You made a appeal. Therefore, I withdraw. However, it is not reflected in order, but it was verbally advised to me. Therefore, realizing that the proper channel is to appeal, therefore, I withdraw.
No, what I mean to say is the executing court observed that this matter is pending, that matter is pending, but in fact, there was no matter pending. Like there was no interim order. There was nothing to prevent the executing court from going ahead. Actually,
yes. But my lord, my humble.
Why? What prompted the executing court to recall? That is the whole thing. There was no point to recall. There was no issue to recall.
No, when this order was passed, recalling order was passed. Already second cover decision was also arrived.
No,
they
that
have already
also
passed
is
second cover decision.
supporting the first kaba only.
Therefore, considering all those things, he might the ADC might have taken the decision to recall the order. However, there was first kaba decision, second kaba decision was also in existence. Because 29/6, the recalling order was in 5/8. That time also the second cover decision came. So the learned ADC might have thought that the first cover decision has been superseded by second cover decision. All those considerations he has recalled the order, not reviewed. It is still there. He has just recalled it.
No,
moreover,
but practically nothing had changed. Nothing had changed. Even if in first kaba, second kaba, even if review, even if the CRP was pending 21, nothing had changed. Actually, the situation was.
My lord, what I'll barely submit is this can be disposed subject to.
No, because
since you
prima facie, this court is of the view that it should interfere with the impugn order. So, what are you suggesting?
My suggestion, my humble and my fair suggestion is, my lord, since second cover decision is also there, and I'm appealing, and the first cover decision I was delayed, my delay was not considered. RSA is here for condemnation of delay. They're considering all those aspects. Plus, my lord, already they are taking the rent now. Even if after recall stay, they are taking the rent. Therefore, I respectfully concede that this may be disposed of subject to the observation that the rent collection and ownership will be outcome of these appeals, Kawang appeals, first and second Kawang appeals. That I can concede, my lord. Since my appeal, if my appeal is admitted, my delay is condoned, it will go back to the trial court. Then if trial court says I am right, the Kawa was not properly conducted, then things will be reversed. Therefore, making an observation that subject to the outcome of Kawa appeal, this may be disposed of. That I can concede, my lord. It's fairly conceding.
What do you say? Are you appearing in before the trial court?
No, not in the trial court, my lord.
Have you served them notice?
They're
that's what I'm
represented.
Their appeal against the second kaba.
That is there. That is pending, my lord.
That is the fair.
My lord, that of the here, my lord, that issue, my lord. Time again, what I'm saying now.
So are you collecting the rent?
Yes, they are collecting now.
Collecting the rent.
Now we are collecting our part, my lord.
Therefore, in fact, this is infrastructure now.
Since we are collecting our part.
Then in that case, even if it was recalled, in effect, you are still collecting.
Yes, my lord. Of course, it's there, my lord. But when there is an order by some quasi-judicial authority, my lord, it's difficult for me, my lord. And otherwise, my lord, today we are not here on what will be the outcome of the
But that's just an
appeals,
suggestion,
everything, my
since
lord.
everything is
It's
there.
not-
Just suggesting.
everything, my lord, what is happened, my lord. Of course, these
No, like I already indicated earlier, we can go strictly by the law. That is
my
another
lord,
thing.
that is
But one thing is the family connection.
my lord.
So the court also doesn't want to create, such a situation that it will create more animosity between the parties. That is the concern of this court.
No, my lord, what, of course, my friend has, what suggestion has been made, my lord. What I understand is that otherwise also, my lord, this rent collection, that ownership and the title, it will be subject to the appeals only, my lord.
Yes.
There, my lord, no observation needs to be there, my lord. It is already,
Automatically,
it will, yes,
it will be decided by the
yes,
court.
my lord. That first cover, my lord. If my friend brother is completed, then I will reply, my lord. Otherwise, you
Continue to collect.
You just complete.
you
then-
complete, my
No, my lord, I was suggesting,
Uh.
but if my lord, I have to go
So,
by
but
date wise.
your main ground, from what I understand, is your main submission is that the first Kaba was just a family decision,
Yes.
and the second Kaba was the main decision of
Which
the
has
Kaba, which has been
superseded first.
appealed against, and you have already appealed against it, and it is pending before the
Yes.
trial court. So, the whatever happened after the first Kaba decision, the CRP or the execution petition, everything that has now no legs to stand on,
Yes.
and so it has become infracted.
Yes.
That's what you.
Yes. Plus recalling, I am justifying that I have not applied for review. It was recalled, not reviewed. The citations given by my senior colleagues is not applicable here because it's for review. And review and recalling is a different thing. My application itself is for the recall of the execution order. And under 115 CPC, inherent power, 151, the execution court can recall its order, execution order. Because the execution order has been obtained fraudulently as far as my submission is concerned. Because one case, he has filed an appeal in the guise of execution before the head Gambura, and again approached the deputy commissioner. The petitioner has set two forum into motion for execution of the family decision. That is also the strong ground that the executing court has recalled their execution order, because he has approached two forum for execution. Because the collection of rent rights arose from the family decision. Therefore, there is no need to file another appeal or another complaint. Execution was there. He has played with the forum of the court, abusing the time of the court.
Yes. Then
This is my main. Actually, I have made a sequence of events. May kindly.
that list of dates is already there. Or yours is another list of dates.
Not list of that sequence of event for
Acha.
better understanding of this code. Asik.
Okay.
Yes, my lord, a short
Yes.
reply, my lord. My lord, it is wrong on the part, to my understanding also, my lord. When my brother says that the decision of this honorable court in CRP 61 at paragraph 11 and 15, it's an obiter dicta, my lord.
That I'm not
yes,
agreeing with.
that I am also, because there is specific finding. My lord. Now, again, my lord, my brother is
What about the
specifically,
point that first Kaba was just a family decision?
that, my lord, that's why I'm relying on this decision of this honorable court only. This honorable court has said, my lord, it's a Kaba, my lord. Decision has been made, my lord. They did not put this to challenge, my lord. If they were aggrieved that this is not a Kaba, my lord, they should have gone on appeal, my lord. They did not do that. They accepted it, my lord. And this was passed in, my lord, 2024, my lord. Almost 2 years back, my lord.
Yes.
Till now, nothing has been done against the order of this honorable court, my lord. What more submission do I need to make that to justify that the first Kaba was a Kaba, my lord?
Decision of this honorable court is also there. Of course, that section 24, of course, I also agree, my lord. That is wrongly mentioned, my lord, but the provision is there for appeal, my lord. Provision
Civil
is
as
there.
well as criminal.
Yes, my lord. Provision is there.
So what is the proper appeal rule?
My lord, now it is under the Civil Courts Act, my lord.
Oh yes, now it has been.
Civil Courts Act, my lord. Under Civil Courts Act, section 15 is there, my lord, under which appeal is to be made, my lord. Now, today also my brother is still denying the judgment passed by this honorable court in CRP 61.
Exactly, my lord, denying.
Now, that
is
another
how I
submission that has been advanced, my lord, is the second kaba has superseded the first kaba, my lord. No, my lord. My lord has gone through the kaba, my lord. It says 16/7/2023, only the already division has been made, my lord. So you collect the rent accordingly, my lord. That is what has been said, my lord.
According to you,
Yes,
it is not superseded, but they have just reiterated.
that in terms of that, you collect the rent, my lord, because second was regarding the rent, my lord. Now, Lord Judgment said, my lord, this, that, whether I have obtained fraudulently, whatever, my lord, but whether that is the ground for recalling the order, my lord, that is not there. It only says multiplicity of proceedings, my lord. And although recall has been said, my lord, it doesn't even have the power to recall, my lord. Basically, it's a review, my lord. It is review the entire proceeding, my lord. We'll see, my lord. It had started with my application, then mentioned the order of January 2024, my lord. At page 15, my lord. Everything has been mentioned, my lord. It is review, my lord, under the garb of recall, my lord, which the judgment that I provided, my lord, it is not applicable. It is no power, my lord. And my brother says, my lord, 151 inherent power is there. No, no, my lord. This execution court doesn't exercise the power of the civil court, my lord. They do not have the power of civil court that they will. Yes, my lord. This is only in the, that is execution is only in spirit, my lord, also, my lord. The application of the CPC, my lord.
Only civil court has the inherent.
Yes, inherent power is there.
Executing court.
This doesn't have, my lord. This is just a magistrate, my lord, the executive magistrate, my lord. That specific power, that quasi-judicial power has been conferred for execution because the village authorities doesn't have the main and power, my lord. The Gamburas. That's why they have been given this power to execute, my lord. That's only thing.
Okay.
That's all.
Heard learned counsel for the petitioner. Mr. Your name?
I'm for the petitioner. This okay.
And also heard Mr. Search for the respondent. So, the hearing is concluded. Or maybe I'll just pass today itself. Just say matter is disposed of. I'll pass the order in the chamber.
My lord. Obliged.
Send this to the chamber.
Sure.